Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I thought I'd do something a little fun and have a look at the gun storage in the first John Wick movie and see if you were to store firearms like this in Canada, would that be legal or not? In order to do that, I'm going to look at the case of the Queen and Porter. But before we get to that, I'm going to play a short clip just so that we're all on the same page as to what I'm talking about here.
You will do nothing.
So what we see in this clip is there was a concrete slab laid over top of a wooden box. That wooden box contains restricted firearms stored without a trigger lock, and it doesn't appear that any of them were stored loaded, but there are magazines next to them that are certainly loaded. The concrete slab was laid to disguise them. In order to get through, there was no opening mechanism. He had to sledgehammer his way through it. And then once he did, he can open the box and retrieve the firearms. So that's sort of what we're talking about as our factual scenario. But let's have a look at the case law because it provides how the court has dealt with similar situations in the past. And this is the case of the Queen and Porter out of British Columbia. And this is a case that's been followed by a number of British Columbia decisions. I haven't seen many outside of British Columbia. We'll have a look at the case here. So he was charged with a couple of counts of storage of a firearm contrary to the firearm storage regulations. And they note the background to these charges stems from a May 16, 2002 recognizance of bail, which Mr. Porter entered into. So he was charged with some other offense, and he was released on bail, and they put conditions on him. Condition 4 of the recognizance prohibited him from being in possession of any firearms and additional described items and any related documentation, including licenses and registration certificates. Condition 5 required him to surrender possession to the Saanich police of any of the same described firearms, items, and related documentation within 24 hours of his release. Mr. Porter was released on May 16, 2002. None of the items described were surrendered. So that's a problem here. The police executed a search warrant at Mr. Porter's residence on November 4th, 2002. We don't have any details here about why they executed the warrant, how they knew to do so, but that's something that we'll just not know from this. The two officers involved, Constables Teague and Sahota, found firearms, a knife, and ammunition in the attic of Mr. Porter's home. Much evidence was given regarding the discrete location of the items in question. The officers first entered a bedroom clothes closet. At the rear of the closet, they pushed aside a pile of clothing and removed a piece of cardboard which covered a door-like entrance through which there was attic access. They crawled into the attic. The only available light was from their flashlights. Within the rafters and exposed studs of the attic space, the officers pulled a wooden panel off a box-like enclosure which jutted into the attic space. 6 other visually similar boxes jutted into the attic space. These 6 are apparently the backs of built-in storage space located within the lived-in portion of the house. The officers testified the wooden cover panel readily came away from the box-like space when Constable Teague pulled on it. Both officers denied needing to use tools to remove the cover panel. Constable Teague testified there were gaps between the cover panel and the sides of the box-like space, such that when he shone his flashlight, he was able to see the items inside prior to removing the cover panel. I accept the evidence of Constables Teague and Sahota. Firearms and ammunition were located inside. So the judge takes this as this is facts. This is what actually happened. So this is an unusual situation, and we'll get to a little bit of the details. There's a big listing of the firearms found. None of them are terribly interesting, but regardless, they are guns is the main portion that we're skipping over here. And you'll note here from the regulations, may store restricted firearms, and one of the things that is sort of always required is securely locked. That's something that we see in every section there, so your storage has to in some fashion be kept securely locked. Other than, non-restricted stored with trigger locks. But in this case, we're talking about containers, and so it's going to be important whether these containers are securely locked. The major issue in respect of each of counts 1 and 2 is the meaning of the phrase in the regulations, kept securely locked as it applied to the storage of the firearms and the ammunition. Defense counsel submits that the phrase should be interpreted according to the intention of Parliament, the objects of the statute, and the everyday normal meaning of the words utilized in the statute. He submits that in the context of this section, kept securely locked must mean kept in a secure manner or prevented from easy access, and should not require a locking device. He characterizes this element as requiring that the container be secured by mechanical means, including screws or nails or other devices. Mr. Morahan cites Bell Express View Limited Partnership and Rex, in which the court adopted the following statement by Dreger, quoted paragraph 26. Today there is only one principle of approach, namely, the words of an act are to be read in their entire context and in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. In the Queen and Mackintosh, a majority of the court, and that's a Supreme Court decision, held that if the meaning of the words in the statute is plain, it must be accepted regardless of consequences. And they say, where by the use of clear and unequivocal language capable of only one meaning, anything is enacted by the legislature, it must be enforced, however harsh or absurd or contrary to common sense the result may be. The fact that a provision gives rise to absurd results is not, in my opinion, sufficient to declare it ambiguous and then embark on a broad-ranging interpretive analysis. However, Dreger note that despite this clear statement, this commitment inevitably wavers when the consequences of applying the plain meaning rule are found to be intolerable. So, continuing on, in my view, the proper approach is therefore to determine whether, in the context of the regulation, the wording of Section 6 is reasonably capable of more than one interpretation. If it is ambiguous, then the court will need to consider external interpretive aids and interpretive principles beyond an analysis of its ordinary meaning and its purpose as reflected by its context. So what all that means is they're trying to see what meanings this could have, and essentially defense counsel is arguing that it being screwed shut is good enough. So defense counsel submits that the intention of the statute is to ensure that the firearms are stored in a receptacle that is constructed so it cannot readily be broken into, and further that the firearms do not create a risk. He submits that the phrase kept securely locked is surplusage in the context of a storage container without an access or entrance. And what surplusage means is essentially meaningless extra words. And the problem with the surplusage argument is that as a general rule of statutory interpretation, we want to avoid meanings that create surplusage. We want to avoid meanings or interpretations of the language that suggest that some of the language used is meaningless, unless it's somehow clearly intended as like a preamble or something like that. But generally, it's something to be avoided. So this is an argument where you know that he's on some weaker ground here. In this case, defense counsel submits that a purposive analysis is appropriate and supports an interpretation of kept securely locked as requiring storage containers to be kept in a secure manner. Further, he suggests that the ordinary meaning interpretation of Section 6b(2) of the regulation cannot be the intended meaning because of its result. For example, that storing firearms in an iron safe, welded shut but without a lock, would be an offense. So we've got another hypothetical here of an iron safe where the lock has somehow been removed or has fallen out, and so somebody's welded it shut instead, and there's just no way to open it short of cutting it or blasting it or whatever else. I am satisfied that the provision is not capable of any interpretation other than its intended meaning, despite this result. Sullivan and Dreger's propositions include the limitation that legislation should be interpreted consistent with its purpose insofar as the language of the text permits. The language of the text at issue does not permit an interpretation eliminating the second requirement, particularly in the context of firearms legislation, where certainty and predictability are integral to the goals and effectiveness of the legislation. The ordinary meaning of the phrase is clear that both requirements, the secure construction of the container and lock, must be met. Both the ordinary meaning of locked and the placement of the phrase after the secure container requirement with the conjunction and indicate that the requirement that the container be kept securely locked means something more than the preceding requirement of a secure container, which could in itself be said to qualify as keeping firearms in a secure manner. In my opinion, the ordinary meaning of the phrase kept securely locked does not encompass fastenings by nails or screws. Kept securely locked is not an ambiguous phrase. This language is understandable to all. It signals to a layperson what the regulation requires. The court should be loath to turn that clear wording into something vague or elusive and then to embark on an unnecessary interpretive journey. So what he's saying here is that it requires a lock. No matter how much better the storage might be than a lock, it's got to have a lock or else it doesn't meet the regulations here. Note that the storage here would not be considered carelessly stored. So if they charged him with the offense of careless storage, John Wick is good here because there's clearly a lot of care and attention put into laying this slab and concealing it and so forth. But also in terms of the actual danger, if you think about, a burglar breaking in, they're not going to get to this. If for some reason he hosted, a children's party and left the house, and the kids had the run of the house and were looking all over the place, they're not going to get to these guns or the grenades because they're not going to be sledgehammering, anything up. And if they are, they're not going to know exactly where to sledgehammer because only John Wick knows that, presumably. So back to the case. While the result that a hidden compartment that is nailed shut is not acceptable storage, while an obviously visible but locked box is acceptable, may arguably be surprising and even illogical, it is not an absurd or inequitable result, as in Rizzo and Rizzo shoes. It does not defeat the purpose of the legislation to require holders of firearms to keep them in locked containers, even if secure containers without locks could arguably be equally secure, nor does it impose harsher penalties or requirements on a particular group of firearms holders. If there is a distinction between firearms holders who store their firearms in locked containers and those who store them in other equally secure containers, it is also a distinction between those who do and do not comply with published regulations according to personal choice. Balanced against the clear wording of the provision, it cannot be said that the result of the provision is so absurd that Parliament cannot have intended it. Further, the wording of Section 86 sub 1 of the Criminal Code suggests that non-compliance with regulations contrary to Section 86 sub 2 was intended to be interpreted strictly according to the meaning of the regulatory requirements without regard to the comparative safety of non-compliant methods of storage. Section 86 sub 1 creates an offense of use, storage, handling of firearms in a careless manner or without reasonable precautions for the safety of other persons. However, Section 86(2) does not include the word careless, but only requires non-compliance with the regulations. In my opinion, this supports the view that the regulations were intended to be enforced according to their ordinary meaning and not to be interpreted contrary to their plain meaning so as to encompass non-compliant, if arguably equally safe, manners of storage. And we can extend that to more safe manners of storage. Kept securely locked means what it says. It does not mean kept in a secure manner. So what we can get from this is that John Wick's storage is contrary to the regulations, because notwithstanding the fact that there's a concrete slab that is going to take you a substantial amount of time to batter through, and notwithstanding that it's hidden from view, and so it's going to be even more difficult to find, because if you knew that he had firearms but you didn't know where in the house they were, you'd probably have to take down the whole house in order to find them. Notwithstanding that, his storage of the firearms is contrary to the regulations. How does he solve the problem? Well, he has to go in and throw a lock on that wooden box, which seems ridiculous when you think about it. It seems ridiculous that that concrete slab is not good enough, but a tiny little lock that is now added onto it, now we're good. That's what this case says. It's a case that quite boldly stands for somewhat ridiculous notions. It basically says this is not so crazy that Parliament couldn't have meant for this to be punished, and so we're going to go ahead and punish people for this. Now, assuming that you're not John Wick, assuming that you're not, a trained assassin with, dozens of murders under your belt and, storing it with grenades, but in fact that you were a lawful gun owner and that you, and I should note here, Mr. Porter was not in a situation of being sort of the lawful, law-abiding gun owner, because he's in a situation where he was actually under bail conditions saying no guns, and he had guns. But if we're talking about somebody who's licensed, who doesn't have any criminal, record or anything like that, or criminal activity on the go, and stored their firearms like this, I suspect that the court would be fairly lenient in terms of the punishment. However, one of the provisions that there is no wiggle room on is Section 491 of the Criminal Code, which says that if they find your firearms in being improperly stored or stored contrary to the regulations, those firearms are subject to seizure. And when they're seized, they're going to be destroyed. So even if the judge is really sympathetic, the guns are going to be destroyed if they're found in this sort of situation. Anyway, I was hoping this would be a little more lighthearted, but it is kind of depressing as a result, because it doesn't feel fair. It doesn't feel right. But that's the judge's reasoning, and this is a case that has been upheld a lot in British Columbia and may well be upheld in other jurisdictions if it were to come up. So thank you. I hope you found this to be enlightening. If you found it to be interesting or educational, please like, share, and subscribe. It really does help the channel grow, and I hope this has armed you with knowledge.